I'm Chance Dorland, and this is The Docket, our weekly interview program covering law and crime in San Antonio from expressnews.com. Brought to you today by the law offices of Pat Maloney. And as always, I'm joined now by San Antonio Express News courts reporter Elizabeth Zavala. Liz, great to have you on the program. As always, we have something interesting to get to. Very big news concerning a case we've already discussed here on the program.
Hey there, Chance. It's great to be back. We had an interesting development in the capital murder trial of Luis Antonio Arroyo, accused in the brutal stabbing and shooting of Rodney Spring and Quiquitha Jackson at an apartment on the west side of San Antonio on January 21st, 2016. Quiquitha's mother, Tandalyn Jackson, also was stabbed and shot, and was the lone survivor and eyewitness of this brutal crime that occurred. Just to remind you what happened, Arroyo was 39 when he was arrested and charged with capital murder, multiple persons, in the attack that occurred at this apartment. The motive that was mentioned during the trial was that Tandalyn Jackson accused Tony Arroyo of stealing a pack of her cigarettes, and it really made her angry. She said that he had been in her house, when her cigarettes went missing from her walker, and she got really angry about it, and she confronted him about it at his apartment, which was not very far from hers. And then later on, when Tony went to her apartment, she would not let him in, and that is when the incident occurred. So, late Thursday, this 2-week trial, a capital murder case where prosecutors were seeking the death penalty, ended in a mistrial. And I'll remind you that what we discussed some last week, that this is the second mistrial in Bexar County in a capital case seeking death that has happened in July. The other case involved a defense attorney who suffered a concussion during jury selection for the capital murder trial of Brian Flores, who is also accused of killing 2 people, and his charge is very similar: capital murder, multiple persons. And a capital murder, if you kill more than one person, you can be charged with capital murder. And this was a double slaying, as was occurred in the Tony Arroyo case. But the difference between the two is that in the Brian Flores case, they had to stop everything in the middle of jury selection because the attorney could not get back to work from the concussion. It was going to take him some time to recuperate from that. But this case, the Arroyo case, was different because this trial was completed and the jury ended up, being split 6-6, which we call deadlocked, and thus the mistrial. First of all, it got a little bit of a slow start the first week because of some scheduling conflicts. And then a juror had a seizure, which sent the panel home early so that the juror could get, properly checked out and to make sure that they were going to be able to continue with the case. So after that, they had at least 4 full days of testimony that included the tearful eyewitness testimony from Keitha's mother, Tandalyn Jackson, who is disabled. She suffers from a couple of ailments, and she uses a wheelchair and a walker at times. And in her testimony, she told the jury that Arroyo kicked her door in, shot her daughter. Tandalyn was thrown to the floor, and Tandalyn Jackson ended up getting stabbed and shot. She was stabbed in the back several times, and then she was shot in the stomach. It was such a traumatic event for her that she testified that she didn't even realize that she had been shot until later on. She painted a very, very detailed picture of what happened to the jury. But there were a couple of things that could not get answered. And in closing arguments is basically, I believe, where everything changed. First of all, in closing, and we've talked about this some before, but the state, which are the prosecutors, they have the burden of proof in this case. They have got to prove beyond a reasonable doubt that this person is guilty in the case. So because of that, they end up arguing twice. They will go first, then the defense will argue their side, and then another prosecutor will come up and finish up for the state. So in his closing arguments, Scott Simpson went straight to the point with the jury and said that Tandalin Jackson was the lone survivor and is a living eyewitness to what happened. And he said that, what more do you need when you've got somebody who said this person did this to me? That proved beyond a reasonable doubt that he was guilty of this crime. Defense attorney Joel Perez, in his closing arguments, and I believe that this is probably where the jury got stuck, where at least half of the jurors got stuck. He pointed out first and foremost that unfortunately everyone involved was on drugs that day. You have 3 people who were smoking crack cocaine. You have 1 person who survived who admitted that they had smoked crack that day. And he was basically attempting to discredit the testimony of Tandalin Jackson. But he also dinged the San Antonio Police Department for what he called a shabby investigation that was riddled with mistakes. And he pointed out that the lead investigator for San Antonio Police, Detective Robert Bunnell, did not secure the crime scene, that there were a lot of police officers that were milling around the crime scene, and specifically also that there were other Tony Arroyos who were in the area who were not investigated. He also mentioned that police left a shell casing inside a pillowcase that contained the gun that they believed to have been used in the crime. He didn't stop there, though. Joel Perez pointed out testimony from one of 2 men who testified that he saw Arroyo before and after the incident. And each time he saw him, he said he was walking calmly. This man was inside a pickup truck with another man. They had been smoking cigarettes and drinking when they saw Arroyo pass. Arroyo asked for a cigarette. They said they didn't have any more, so the witness said he went on his way. Then they heard the gunshots. And then moments later, they saw Tony Arroyo walking back toward his apartment. Now, they said the first time when he was walking toward the apartment of the Jacksons. And then when he's walking back, he was walking back toward his apartment. But the thing that Joel Perez specifically pointed out to the jurors was that the witness said that each time he saw him, he was calm. So Perez asked the question to the jurors: if Arroyo had just committed such a rage-filled crime, why was he so calm? So in her closing arguments, Bexar County Assistant District Attorney Mari Jensen went straight to the point with the jury and began her argument for the state by playing the 911 recording where Tandalin Jackson can be heard saying the words, "Oh Jesus, oh Jesus, oh Lord, Tony, please stop. Tony, stop it." And pointed out to the jury that even, Tandalin herself said that, part of the reason that she wanted, and she did testify to this, that part of the reason that she called 911 and left the phone on so that 911 could hear her was because she actually said that she'd seen that on television, that when people are incapacitated and they can't get up, but they've got their phone, they can call and they leave it on. So that way authorities can find them. So she left that phone on and they played it in court during last week's or during the first week. And then Mari Jensen played part of it again. But, in the end, this jury that listened to Tandalin Jackson describe the stabbing and shooting deaths of her daughter and Rodney Spring in detail and heard her name, Tony, as the killer in that 911 recording, couldn't reach agreement on whether Luis Antonio Arroyo was guilty. And that forced the judge to declare a mistrial Thursday. Some courthouse observers say jurors should be allowed to deliberate at least half of the total hours that they heard testimony in a case. I think some judges pay really close attention to the demeanor of their panels. In this case, State District Judge Kevin O'Connell, on the first communication with jurors when they said they were deadlocked, did what is called reading them the Allen charge, which basically is telling them that if they can't reach a decision, another jury will have to be selected and they would have the same evidence, the same witnesses, the same stuff as they did to consider. So he asked them to please go back to the deliberation room and try to reach a verdict. Well, about 2 hours after that, the jurors sent out another note saying that they could not convince the 6 to change their minds. So Judge Kevin O'Connell polled each one by one, and he asked them this question: do you believe that there is a reasonable probability that the jury can reach a unanimous verdict in this case if sent back to the jury room for further deliberations? So what happened next, and I'd never seen this before, Judge O'Connell had each of the 12 jurors come into the court one by one and sit in the jury box, and he asked them one by one, and each responded no. So he declared a mistrial.
You're listening to The Docket, a new weekly interview program covering law and crime in San Antonio from expressnews.com, brought to you by our sponsor, the law offices of Pat Maloney. So, Liz, of course, that type of thing happening in a case in Bexar County is obviously not an everyday circumstance. So now I'm wondering, what was the reaction when that verdict was read?
Well, as Judge O'Connell was talking to the jurors before he declared the mistrial, you could tell that, these jurors worked really hard. Some of them wept as they were thanked for their service after Judge O'Connell declared the mistrial. As far as the attorneys go, bewildered is how I would describe the faces of prosecutors Scott Simpson, Mari Jensen, and Clint Malloy, as well as defense attorneys Joel Perez and Raymond Fuchs. However, make no mistake, this, even though it ended in a mistrial, this is like a win for the defense, because Perez's closing argument obviously got to the jury. Prosecutors declined to comment because they have to retry this case, likely this year. And when I tried to reach defense attorneys on Friday, they were not available. Hey, they're likely resting after this grueling 2-week trial because it was, it was pretty grueling. I mean, that's a lot of information, to present, a lot of evidence to present. And it's a lot for a jury, to listen to and to consider, especially if they have it at the back of their minds that, they realize that they're going to be asked to send someone to death row. So what happens next in this case? This is a second mistrial in a capital case that is seeking the death penalty. But this was the first death penalty case in Bexar County since Mark Anthony Gonzalez was condemned in 2015 for killing Bexar County Sheriff Sergeant Kenneth Vann 4 years earlier. Before then, a Bexar County jury hadn't decided that someone deserved the death penalty since 2009. So that's a pretty big deal. But as far as this case goes, Arroyo's case stays on Judge O'Connell's docket, and it's going to be reset for another time. I imagine that what's going to happen next is going to be that the prosecutors for the Bexar County District Attorney's Office are going to be reviewing, how the case went down, probably, figure out, scheduling and what they're going to do next. But they do indeed plan on trying this case again. It's not gone away. A mistrial does not take anything away. It will just be reset for another time. And in the meantime, it'll be interesting to see, if the defense will be able to talk with me at another time to see, to answer some questions, because I would be curious to see, from them what they felt went right for them in this particular case. I will be crossing my fingers to see if they can actually divulge any of that, because it could be a situation just like the prosecutors where, the defense doesn't want to discuss it. They may not want to show their hand for any other time that this will, go to a jury. But, it's going to be another situation where if, we'll be calling another set of potential jurors to seat a panel. And, when you are trying to seat a panel for a death penalty case, it's not like a regular jury where, you can be called and it takes maybe a half a day, maybe a whole day to seat a jury. When you're considering a capital murder case and you're going to send someone to death row, you've got to call at least 1,000 people. It can take up to a month to do this, maybe more. In this particular case, it took just a couple of weeks to seat this jury. So it's going to be another lengthy experience for the court when Luis Antonio Arroyo's capital murder multiple persons case comes back up again in Bexar County.
All right, Liz. Well, that is quite a story. Obviously, we're going to keep covering this case here on the docket, as well as many more in the future. So we're going to let you go today, and I look forward to having you back on the program next week.
Yes, thank you very much, Chance. It was good to be back. And, until next time, thanks.
And of course, a big thanks to San Antonio Express News court reporter Elizabeth Zavala for joining me for today's episode of The Docket with all those great details we just discussed here on our weekly interview program covering law and crime in San Antonio from expressnews.com, brought to you today by the law offices of Pat Maloney. For the San Antonio Express News, I'm Chance Dorlin.